Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back to the Men's Divorce Podcast. I'm Scott Trout, Managing Partner and CEO, Cordell and Cordell. And we're today going to talk to you about how to be your best advocate. And that's a very general topic, but we're going to get really specific about some tips that you should consider to be your best advocate. And that is take some notes. Again, not legal advice. These are just ideas, educational information based upon our experience, just like we do every time we talk on our podcast. And today is no different. But if you haven't tuned in to our Men's Divorce Podcast Live, that is a virtual town hall where we do once a month. Instead of a recorded podcast like this, we go live and it's streamed on Facebook and YouTube. You can join for free. All you have to do is register. You can log in and ask questions and get answers right there from a panel of Cordell and Cordell attorneys and typically guests. Last month, we talked with a tax attorney. Many people going through divorce and family law matters have tax questions, and that's what we did. And next month, keep an eye out. We'll bring some more information for you on the Men's Divorce Podcast Live. So remember to subscribe to our podcast. You'll get alerted every time something's dropped as well. You can check out our social media, Facebook, YouTube channel as well. Everything is there for your information. So today we're joined by one of our litigation partners, Tiffany McWhorter. Welcome.
Good morning. Thank you.
So being your best advocate, that means a lot of things. And we often try to get away from the law side, talking about statutes and case law and, whether or not you're meeting a burden of proof. And this would be something different today where we talk about being an advocate for yourself. But that means obviously coordinating with your attorney like you, where we would start kind of with, preparation before the case or maybe even during. We've talked a lot about this in some of my seminars that I give in person. We talk about documenting and keeping a calendar. That's really, really important, isn't it?
Absolutely. And what I want to focus on, and as you stated, we often talk about the technical side, but what I found with my clients, the best way for us to feel comfortable in the courtroom, feel comfortable when we're going into a hearing. Obviously, this is a very emotionally straining process, but I find that I want to be the most prepared person in the room. And that's what I try to convey to my clients, is that you will be amazed how differently you feel when you can relax, at least about knowing that you know what to expect, knowing that you have done everything that you can to prepare for that day when you're either sitting in front of a judge for a final trial or even in front of maybe a magistrate or associate judge for a minor hearing. Anytime that you can go into that courtroom knowing that you've done everything possible to prepare, that you and your attorney are in sync with one another and know what you're going to be presenting, I believe that it gives our clients the confidence to know that they're absolutely putting their best foot forward as we get started in what can be some very stressful litigation.
Yeah, I mean, it tends to give you some relief in that regard. For example, if you're going through a surgery or you have a procedure, I'm going to research what do they do, what's it like, how long does it last. It makes me feel more informed and better about what my choices are. Is to be, as you suggest, be more prepared and investigate, ask questions, and this is just part of it. And in terms of, I was just talking with a client the other day about some some behavior issues by his spouse, and I said, look, let's start keeping a journal. Let's start, recording, so we know that when we look back, it's kind of this fresh recollection recorded. So documenting and keeping a calendar when things occurred, when she left and when she came back, that's important.
Absolutely. And that touches on the first topic that I always go through with my clients, which is document everything. Document. And it's not because we're trying to spy on the other spouse or we're trying to build our case or paper a file. But there is comfort in knowing that you're not going to be sitting in front of a judge or in front of your own attorney trying to recall events you don't know the dates, you don't know the specifics, you can't recall exactly what was said. But the first thing I always say is keep a calendar, keep it with you, whether it's on your phone, make sure it's backed up to the cloud that only you have access to. But anytime an event occurs while you're going through a divorce, you need to be present. Be present in that moment to just jot a quick note, put a little note on your phone. Whether it's something like you have conflict and it occurs in front of your children, you want to make a note of that. So that's something that if you're asked later, what are some parenting concerns you have? You can go right to that calendar and look and say, for example, on this day, this event occurred, and you can better relate to your audience, whether it be the judge or your attorney, how that impacted your children, if that's one of the issues in your case. Also, kind of with what you said on calendar, it's very important if we're talking about custody to make notes on events that you're attending or activities you're doing with your children. It sounds a little counterintuitive because you're, again, not trying to document or build a case. But if you're going to that soccer game on a Saturday, put that on your calendar. If you are tasked with bringing maybe gifts or goodie bags or what have you to the school, put that on your calendar. Those are things that you do all the time that you're not going to remember. But I promise when you're sitting in a courtroom and you're listening to your spouse detail everything that they've done for the school, or the children for sports or whatever it may be, you will have a lot of comfort in knowing that you can look at your calendar and make the timeline for yourself to really to showcase that you are also an equal partner or maybe doing more than your spouse in those situations.
Yeah, it's funny you mentioned, keeping a calendar. I use Cozy. We've talked a lot about different calendar apps, Family Wizard and Cozy. Just for me, I'm not in the middle of divorce, but I can't remember half the stuff that I did. And so the nice thing is I can search through, oh yeah, I remember when was that and what did I do? And I keep, notes and what I'm doing and where I'm going. And it's just a nice way to just keep a fresh recollection rather than having to, stress often changes perhaps our recollection. And you want it to be fresh. You want it to be in the moment. And calendaring and notes, those are always big as well. And I talk about photos. Photos are always a big thing, especially when we're anticipating a divorce. I talk about taking photos of inventory of the house. I talk about taking photos that show you in activities with your kids. I think that's important. We just went through Halloween, and whether or not you have young kids that you took them out, photos are important.
Yeah, and I'm glad that you mentioned that about the inventory, because that is something I tell my clients the minute we sit down and start talking about their case, before we even begin on the particulars of the facts. And maybe some people are like me. I have a tendency to forget all of the details and all of the little things. But what I encourage clients to do is to go in each room of your house, just stand in the middle, take photos as you look around. Take photos in your garage, especially. If you're a guy that likes a lot of tools, or maybe you have other hobbies that you do, or maybe you have firearms, things of that nature, you want to take photos of all of the things that are in your house, which seems maybe odd, but what you'll realize is during a divorce, you may have the task of preparing your inventory, or you may be asked during mediation, especially if you vacated the residence or if you put things in storage. What items do you want out of the house? Well, I will tell you, there's no way I could remember everything that I would consider mine or that is important to me. But what I have my clients do, bring those photos with us to mediation. Let's just flip through them and let's just see if there's anything in particular that you care about. Make sure that's on the list. Make sure that if you've got some kind of gift that maybe you got for Father's Day that everybody uses, maybe it's a guitar, maybe it's something, golf club, something. You at least want to be able to look at those photos and say, that doesn't matter, this does matter, but you walk out knowing that you've considered everything. But the other flip side to that is, I'm sure we've all had those cases where clients put something on the list that they want, and before we know it, oh, well, that's not here anymore. Oh, well, you didn't have that, or that got lost in the last move. Well, if you've got photos that are relevant in time to when your divorce starts, you can absolutely document, well, that was in the garage 2 weeks ago, or that happened to be in the storage unit and we moved everything in there. And I think that's important just for peace of mind, but also to make sure that you're considering all of your property when you're dividing your assets.
Yeah. You talk about capturing a photo. This week, I was just talking with a client about recording and capturing some financial misconduct. where a spouse we just filed, and before filing, spouse decided to go on a spending spree of things that really are not necessary and they're not usual. It's not in accordance with their standard of living, and just decided to just waste money. And so not only that, but draining accounts and going on trips and vacations. So capture those financial issues that you think are suspicious and you want to talk about and have the court consider.
That's a good point. And that's another part of the documentation that I encourage clients to do is I'm one that I don't typically flip through my bank records. I don't typically, unless I'm looking for something in particular, I don't take note. And that's something I should probably work on myself. But when you're in this time where you are going to need to be focused, look for those unusual spending patterns. Often, and this was a trend for a while, when parties would be able to go into, say, a grocery and get cash back for groceries. And before you knew it, you see transactions at the local grocery store that are normally one amount and now they're hundreds more. Or you just start documenting where there's potential that someone is getting cash back, or they're taking out cash withdrawals, which if you look back a year ago, you don't see these same patterns. If you can document for that information for your attorney, there's no way we can know what your typical patterns are. But if you can look at what you're spending and know these are particular nuances in your documents that we would never pick up on because we're not in your household, those are exactly the kind of things that you want to document and capture. These unusual patterns, if you look back in time to see that didn't occur prior to the preparation for divorce.
Right. And you think through, just there's so much more in terms of what you would want to start preparing in advance, but in terms of documentation and photos. But as we kind of progress in through the case, you want to spend some time gathering all of that. You've taken the time to do it. Now you want to gather and give it to your attorney. You can do some of this work on your own and save some of that expense by getting, records that helps your attorney formulate strategies and position. Some things may ultimately have to be subpoenaed for evidentiary purposes and admission into court records and those types of things. But it could be anywhere from records of financial to text messages to emails to social media. So you want to gather all that and give that to your attorney, because the things that you think maybe are meaningless and unsupportive or not very helpful tend to be the opposite for the attorney.
Right. And that touches on another part of litigation, in that your attorney is likely to have been in front of your particular judge on several occasions. They may know that there's certain issues in front of a particular judge that really raise the judge's hackles, or there are certain issues that if you focus your testimony on a particular topic, your judge is taking note. And so if you go ahead and get that information, and I will tell you, like you mentioned, it is absolutely a cost saver for a client. If they can get, for example, a USB storage device, they can organize their documents in folders for their attorney, text messages regarding our trip, text messages regarding the school, whatever it may be. When the attorney looks through those, they may pick up on a topic that they happen to know will be relevant, that may seem like just casual conversation or argument. But for example, I was in front of a judge recently, and I happen to know that there's a particular topic that this judge really becomes incensed about. And it's a particular communications in front of children that tend to either emasculate a father or in some way make the children look at the father like he's for lack of better terms, not the provider. Right. I know that judge, and I know that is a big topic. So anytime I look at text messages and I see that kind of banter or I see that kind of communication, I am keying in on that, because that's going to be exhibit number one that I'm going to put forward. So you're right. Being your best advocate means pulling all that information together so that when you walk into your attorney's office for that first meeting, you've got the documents collected. Sure, the attorney, like you said, may need to subpoena documents, but you've got, and we'll talk about more in a minute, some lists and questions to prepare for your attorney. But you are coming in the best position to be able to build your timeline with your attorney and build your story that you're going to tell.
And you mentioned the list of questions, preparing for the meeting with your attorney, whether it's the very first meeting, whether it's a subsequent meeting and in the middle of your case. I think about being proactive in that regard. For example, I have a doctor where I do an annual blood work, and I get this booklet of this blood work. I mean, and it's like 15 pages of blood work. And he sends it to me in advance and then sets the meeting later rather than giving me the booklet. And I don't know what to ask, and I'm just listening. So he gives me the booklet with intent that I go through it and I circle things and I highlight. I'm like, what does this mean? I have no idea what HBPPOA, what is that in my blood? And so that's the point, that you should treat that meeting with your attorney just like you would with a doctor. If if you have questions, make a list of questions, make a list of what are my goals? What's the best and the worst case? What is it I'd be willing to settle for? Make that meeting substantive, and then, bring things with you, whatever questions or lists of witnesses or people. I mean, that's the gambit that you want to make. You're spending really good money, and it's never cheap to go through a very highly litigious divorce. So make those meetings very, very fruitful.
That is an excellent point that helps your attorney prepare to make the most of that hearing. It's easy when we're all busy and we all have schedules that we're trying to meet and deadlines, but these attorney meetings really are so important because this is your opportunity to clear your schedule. Take some time that you can block off the time to really sit down with your attorney. I tell you that I have, boxes and boxes of notes in some of my cases. The most helpful are the ones where the client has provided me. Maybe it's a Word document. I tell them just leave it open on your work computer throughout the week. If you think of questions, put them on that Word document. We'll organize our thoughts when we get to our meeting. But that way they kind of have a running list as we go. But the most helpful, I use those as my checklist. And a checklist is another thing that I think is important that we can talk about. But I use my clients, their typed notes that they've sent me, and I make that into our checklist to make sure that in our meeting, I'm answering every question. The other type of checklist I like my clients to prepare is going into that hearing. I want to know what is the one thing, or maybe two things, whatever it may be, that you want to make sure you hear come out of my mouth or you see me introduce into evidence. Yeah. I want to know those things because I make a checklist of my own, but then I put my clients on there too, so that while we're sitting at counsel table, I'm marking them off. So that when we walk away, I don't have to be concerned that you're going to look to me and say, hey, you never mentioned that Halloween party, or you never mentioned that the series where you stopped paying the mortgage. I've got that on my list. And that's the best way I think that you can get some satisfaction out of your hearing, that you put all the evidence that was important to you forward by doing that for your attorney.
I mean, you think about, there's so many comparisons to family law, divorce, and preparation. I'm thinking about, these presidential debates. Do you really think with all that's on the line that they just wing it, that they go in and they don't think about the topics, they don't think about the questions, the answers, whatever they want to talk, their highlights, their lowlights, what they look like, what they act like, they go through so much. And think about it. Look, in the grand scheme of things, I think family law is more important than the presidential debate, especially if you've got your property, you work for your kids. That's what's so important, is to really thoroughly, and that's also what I think sets apart attorneys who practice exclusively in family law, like we do at Cordell and Cordell. That preparation is key. That's what sets us apart from someone who dabbles in the area, that thinks, well, we'll settle the case anyway. And I think I've always said, we say we're a domestic litigation firm. That doesn't mean we try every single case, but what I really believe is thorough and proper and convincing preparation for trial leads to really good potentials for settlement. Because you're not going to settle unless there's a weakness. It's like negotiation. If I'm buying a car, if they don't really need to sell the car, they're not going to really sell me the car for a good discount. If they really need to sell me the car because they got a ton of inventory, well, there's a weakness. I know what that is. I'm in the middle of something this week and we're playing on their weakness. We know we have leverage, and that is, so we're trying to find a superior position. But again, we're going flying through all this. There's just so much when we talk about being a best advocate. But I talk about presidential debates. A lot goes into appearance. There's a famous debate where Richard Nixon was sweating during his presidential debate, and that was a sign of weakness, in that he was profusely sweating. And whether he was nervous, afraid, or whatever it may be, but court appearance, how you look, that's equally important.
Absolutely. I tell this horror story with permission of my client because he did think it was funny. I represented an older gentleman, and here in the South, we frequently say, well, I'll meet you at court, wear your Sunday go to meeting clothes or what have you, or wear your Sunday best, what have you. I'm not kidding. And he's such a dear man that I still keep in touch with. He came to court in shorts and a hat. And I asked him, what in the world? I told you to wear your Sunday clothes. And he said, well, I play golf on Sundays. And I just thought, okay, surely there's no way we miscommunicated. But what you're saying is absolutely true. You only get a few minutes in front of some judges. The moment you walk in, they're humans. They're looking at who's there, who's presented, and the comment you made about the presidential debate. I absolutely tell my clients, make sure you know how to get to the courthouse. Do a dry run if you have to, especially if you're in a downtown area you're not familiar with. We'll meet at the courthouse an hour early. We won't be running in from the parking lot after we've tried to find a parking place. We're going to meet early. We're going to come in. We're going to be dressed appropriately for whatever region in the country that we're in, what's expected in that court.
Yeah.
We are going to go over those things. Don't worry about not being confident. You're going to be confident when you come in after working with your attorney. You're going to know what to expect. So we can fix those little details as far as let's meet there early. If there are witnesses or family members that are going to be a distraction to you or that you have concerns about, talk to your attorney. If there are going to be topics that are not ones that you want your family members to hear, you may love your mom dearly and she may want to support you. It's okay to say, this is so important and this is my family here. We need to tell some people that maybe they don't need to attend that day.
Yeah.
Or we have an evidentiary rule where I tell them, I may call you as a witness, so I'm going to have you sit outside so that those people are not in the courtroom. We want to make sure that you're comfortable. And those are the little things that sometimes you don't think about as details that we want to make sure that we're covering before you ever step foot in that courtroom.
You mentioned, the funny story. So I have, I've been practicing for 31 years and it's evolved over time and watching mistakes by clients. And so what I tend to do is, like, for example, what I'm wearing today. The other day, the client, I knew we were going to prep him for what to wear to court. So I wore what I'm wearing now, but I have khakis on. Something I said, okay, I wear business professional to court, tie, suit. I said, but today I wanted to show you what the bottom is. You wear what I'm wearing or better. And I try to give them an example because if you say business casual, you just never really know. And so what I do is I set the bottom. And I'll try to do that in advance. And you should ask your attorney, say, you know what, in our meeting, would you wear what I should wear? Or, that way, I just think that's a good thing to do. And lawyers who really trust the process of preparation will do that as well. And it kind of, as we round out, I know, again, we could talk for an hour on this. It really is ask your attorney about deadlines. Maybe it's post-court. Ask what you should be worrying about. What are the timelines for judgment coming out, for appeal? What should I be concerned about so I can calendar them so you and I can communicate as to make sure that we're protecting ourselves?
Absolutely. And like you said, we've talked about the document phase, the preparation and meeting, and then the actual court. But it is key, like you said, to recap with your lawyer when you walk out of the courtroom. You may be waiting on a ruling. There are oftentimes the court will say, I'm going to take this under advisement, and then maybe a few days. Make sure you're clear on what are we doing in the interim. Also, make sure you're clear on if the court has said that I need to pay support by a certain date, you don't want to miss that day. Or if the court has said, we're going to start this new custody schedule on Friday, you want to make sure that you know exactly what's expected. But again, like you mentioned, there are certain deadlines that we have that we can't miss. We can't go back if we do miss those deadlines, sometimes in the phases of a trial or of just litigation. Make sure that you're clear with your attorney that you know what's expected in your next steps after you leave the courthouse, so that, for example, you don't have a situation where one parent thinks they're picking up the children and the other parent thinks that the other parent's getting them and no one's showing up, or a bill's not getting paid. You want to make sure that you're very clear on what are our next steps after we leave the courthouse.
Well, again, I think we could go in for another 30 minutes at least to talk about some of the details, but I wanted to leave it there. Tiffany, thanks for joining and filling in our listeners and watchers. I appreciate it.
Thanks for having me. I appreciate it.
There's so much more to being your best advocate in preparation, and it all starts with finding the right attorney. and that, again, who practices exclusively in family law, do one thing well. And that's what we do at Cordell and Cordell. And if you want a consultation to learn more about this and learn more about us, you can do that by going to cordell.com. You can schedule a consult right there. You don't even need to pick up the phone. There's a calendar. You put in your zip code or your address. It'll locate the office closest to you and give you options, and you pick what you want. You can do it in person, on phone, or via online, Zoom, WebEx, Teams, whatever is convenient for you. Or you can give us a call at 866-DADS-LAW, 866-DADS-LAW to do that as well and get more information about what we do. So again, remember, Men's Divorce Podcast Live, that will be this month, and you want to tune into that, where you can log on, and ask questions live of our panel of guests and attorneys and get answers right then and right there. So until next time, have a great week.